Well, we'd like to welcome Eric, Athey, and Micah Saul from our dear friends at McNees Wallace. We're happy to have you. And Eric, I believe you're starting it off this morning.
I am. Thank you very much. Good morning, everyone, and thank you for having us. I'm Eric Athey, and I'm joined by my partner, Micah Saul. We're both from McNees, Wallace, and Nurick, and practice here in Lancaster, representing employers in employment and labor law matters, including workers' compensation, basically defending employers from any of the nasty things that employees can bring against them. We have an hour here to talk to you about recent developments in labor and employment law. And it's interesting. We've been doing these updates I've been doing them for about 30 years. And some years we really have to look hard to find something to talk about. Other years it's like a fire hose, and it's a matter of trying to figure out what we're going to cover and what we're not going to cover. This year, we don't have a ton of topics, but I would say that the topics are all pretty broad, pretty important, and likely to apply to many of you. So I think it's worth listening to. And with that, let's see if I can get my click in. There we go. Okay. Now we're cooking. So just a quick overview of what we're going to be covering today. We're going to be talking a little bit about a wage and hour update, some new developments in wage and hour law, some developments in the area of non-compete law, a number of items Micah is going to be talking about involving EEO law. We have some information regarding the National Labor Relations Board and their activities. Typically, the NLRB is associated with only union employers. However, there have been a number of decisions that directly impact non-union employers. So don't leave the monitor just because we're getting into NLRB developments. And then lastly, Mike is going to be talking to you about a recent decision involving holiday parties and employer liabilities. That's a topic that I love. If it always goes over big in holiday party conversations. So if you want to sound like the smartest person in the room, stay tuned for that final slide. The first decision I wanted to talk to you about, you'll see at the very top there, it's a decision that came down in July 2021, and you may be asking yourself, I thought this was an update. That's 2 years ago. The reason it's important is that this Amazon decision that came down in July 2021 was a big deal when it came down, but it left a lot of questions open, and those questions are, I can't say that they've been answered yet, but we're starting to see the fallout from the decision in that it has spawned a literal tidal wave of litigation against employers. And I wanted to alert you to what's going on there. So for those of you that don't remember from the first time we talked about the Amazon case, essentially what we had is Amazon obviously has a number of enormous warehouses, some of which are here in Lancaster County. And they have a practice, as do many employers, warehousing employers, of having a security check at the end of every shift where employees stand in line, go through some sort of detector or some sort of possible frisk or opening up their lunchbox, what have you. And clearly that activity, that security check takes a little bit of time, may take a minute, may take 2 minutes, depending on how many employees are clocking out at that particular period of time. It's an issue, the issue is whether the time spent by employees engaging in those sorts of security checks has to be paid, because clearly it's a little bit of time at the end of the day that they otherwise could be heading to their car. The issue arose initially under federal law, the Fair Labor Standards Act, and the Supreme Court of the United States actually held, we're not going to require employers to pay for such a small sliver of time. There's a sort of a doctrine under the Fair Labor Standards Act known as the de minimis doctrine, where essentially they say that employers can ignore tiny little fragments of time, like a minute or two, as long as it doesn't become more substantial. Plaintiffs in those decisions decided to redirect their efforts, having lost at the U.S. Supreme Court level, and started redirecting their efforts under state laws. Pennsylvania and many other states have their own version of the Fair Labor Standards Act. In Pennsylvania, it's known as the Minimum Wage Act. And the Minimum Wage Act is not identical to the Fair Labor Standards Act. So PA law, the PA statute is not identical to the federal statute. For decades, many courts, including Pennsylvania courts, and many attorneys on both sides of the fence assumed that the two laws were to be interpreted identically. However, in the past 10, 12 years, Pennsylvania courts have started to take notice of small distinctions in the two laws, and those distinctions have cost certain employers a lot of money. And in fact, that's what happened here. The plaintiffs' attorneys tried their luck before Pennsylvania courts, and the Supreme Court of Pennsylvania, not the U.S. Supreme Court, was asked to determine, what about these security checks? Are they compensable under Pennsylvania law? The PA Supreme Court took a look at the regulatory definition of hours worked. That's the second bullet point here. And the regulatory definition that's been in effect for about, well, since I think 1961, says that hours worked includes time during which an employee is required by the employer to be on the premises of the employer. So if we have security checks, these are clearly required by the employer. You can't just walk out the door. So that's strike one under that regulation. And the court said, yeah, I mean, these security checks would meet the definition of hours worked under Pennsylvania regs. The question then becomes, well, does Pennsylvania have a de minimis rule? Can we ignore a minute here or a minute there under this de minimis concept? And this is where attorneys like myself defending employers really were sort of aghast by the PA Supreme Court's decision. They said, no, there is no de minimis rule. It's not mentioned in the state law, and we're not going to impose one. Notably, it's not mentioned in the federal law either. But way back, the U.S. Department of Labor sort of adopted a de minimis standard. So ultimately, what we have is the Supreme Court of Pennsylvania saying, if you require anything of any employee, regardless of whether it's 15 seconds or a minute and a half, you have to pay for it, which is new and rather aggravating and often difficult for employers to comply with. So what has this meant for employers? Well, it's meant a tidal wave of class action lawsuits bubbling up right here in good old Pennsylvania since 2021. I'm involved in defending one right now. I have colleagues that are defending several others. I suspect your counsel, if they have labor and employment capacity, are probably defending them as well. Specifically, these class action lawsuits tend to be brought, many of them are brought by a firm out of Philadelphia using a national firm out of Boston as sort of backup. But the sorts of claims that we're seeing are claims involving employees' time spent waiting for COVID screening or COVID questionnaires, back in 2020 and parts of 2021. Now, interestingly, that particular issue, if you haven't been sued yet, the time is running out because there's a 2 or possibly 3-year statute of limitations for these claims. And, with every day that passes, the COVID screening or questionnaire issue is becoming more and more moot under the statute of limitations. However, there's a menu of other potential issues out there. We're seeing a number of claims involving time spent by employees walking to and from their workstation. So here what we're saying is, or here's what they are alleging is, well, our employees are required to swipe into the building, but it takes them 15 minutes to get to their actual workstation, and they're not on the clock until they're at the workstation. So we want compensation for the time spent walking to and from the workstation. We see, and this isn't a new one, but if you have employees that are required to don or doff uniforms or PPE, and donning and doffing is an archaic term for putting on, taking off uniforms or personal protective equipment. If they're not paid for that and it's required on site, that may be compensable. We've seen some claims from these plaintiffs' firms saying, hey, the second an employee has to swipe into a building or swipe into a parking lot, if the swipe is required, that's work and the time should start then. And the other good one for particularly for teleworkers is we're seeing claims that time spent logging on or off a computer at the beginning or end of the shift has to be paid for. Now, I'm not saying, and please mark my words here, I'm not saying that the law has yet approved of these claims. What I'm saying is that these claims are being filed right now in light of the Amazon decision and in light of the fact that the Pennsylvania Supreme Court rejected the notion of a de minimis exception. So it's not the law, but plaintiffs' attorneys are arguing that that's how the law should be interpreted in light of the Amazon case. What do we do about this? Probably the most, I guess a few things. This decision has caused significant headaches for major employers. The Pennsylvania Chamber of Business and Industry is trying to get legislation passed to perhaps undo the court decision. We actually have a partner who's on their legal strategies committee, and he says that this is job one for the PA Chamber. Whether they're successful or not is difficult to predict, but it is certainly high on their priority list. In terms of what you can do in the interim, if the decision is not reversed, because again, these lawsuits are coming fast and furious, probably the most important thing is to take a look at your timekeeping practices and ensuring that those timekeeping practices capture all compensable activities. Does that mean that you have to pay employees the second they swipe into a parking lot? Hopefully not. That's an argument they're making. But clearly, if we have, situations like security checks, situations like we require employees to put on a work smock or protective boots or safety glasses, those sorts of things, if they're required to take place on site, that would be compensable activity. The best lesson there is just be aware of the issue, talk to counsel, make sure you're protecting yourself as best you can. To give you a sense of liability, I didn't include it in the slides, but let's say we have some sort of an activity that takes an additional minute at the beginning of the day and an additional minute at the end of the day that we're not paying for. So historically, we'd forget about that because it's de minimis. But let's say it's a matter of putting on a smock. They have to walk into a locker room, get a smock, put it on, and then take it off at the end of the day in the locker room. And let's say that takes about a minute. Well, so it's 2 minutes because we've got a minute at the beginning of the day and the end of the day, 2 minutes a day. Let's assume 200 days, work days out of the year. So 2 minutes for 200 days. And let's say you have 200 employees. Well, at least the minimum, under the Minimum Wage Act, they're going to be looking back at least 2 years, possibly 3. But let's give ourselves the benefit of the doubt and say it's going to be 2 years, not 3. So a 2-year look back. And of course, let's say these employees are already working 40 hours. So those 2 minutes every day is overtime. So it's not a minute per minute. It's a minute for a time and a half. And let's say that all of those 200 employees are paid about $20 an hour. With those factors, those 2 minutes a day over the course of 2 years becomes an $80,000 liability. It adds up. Obviously, if you have more employees, it will increase proportionally. And likewise, if that 2 minutes is more like 4 minutes, 5 minutes, 10 minutes, it's going to increase proportionally. So it's a number that adds up, and it's certainly a number that is that's worth your attention. You may be a hero in protecting your company against that liability if you can get out ahead of it. So the industries most likely affected, large warehouses like Amazon are really the main focus of these lawsuits from what we've seen, but they're not the only focus. We see suits being filed against construction companies, specifically situations where a construction contractor may be working on a very large corporate site, and the workers can't drive their vehicles onto the site, but they sort of meet at a location, and then a company vehicle takes them, to their particular work area. That time spent in the company vehicle driving from outside the site onto their actual point of work would be compensable time, which would add up. High security facilities, if there's a particular security protocol that's required, obviously could create exposure. Heavy industry, if you have requirements that employees have to put on certain protective equipment or engage in any other particular required cleanup, could be a compensable issue. Food service is sort of the classic issue of, are employees being paid for the time setting up their workstation, getting the food or getting the silverware or the table set. And obviously, the one that applies to probably all of you is the time during which employees were required to be on site for COVID screenings, if you actually had employees on site during the lockdown. So that's Amazon in a nutshell. Many of you probably have some sort of small issue that you may want to take a look at, and probably all of you have some policy cleanup to do on that particular point. Moving back from the Pennsylvania Minimum Wage Act, we're back into federal land here, and you may recall that back in, I believe, 2016 and also 2020, there was the question of whether the minimum salary paid to employees who were treated as exempt under the white collar exemptions, those are the executive, administrative, and professional exemptions, the minimum salary necessary to qualify has become a bit of a battleground issue with certain legislators pushing for the minimum salary to increase in order for an employee to be treated as exempt and not entitled to overtime. Currently, the minimum salary for these white collar exemptions under federal law is $684 per week, or $35,308 annually. The Department of Labor, the U.S. Department of Labor, proposed that that minimum salary increase to be the equivalent of the 35th percentile of weekly earnings of all full-time salaried workers in the lowest U.S. Census region, which equates to $1,059 per week, or roughly $55,000 annually. Again, this is a proposed regulation at this point. It's not likely to pass in 2023. If it does pass, it's likely to happen in 2024. There will likely be lawsuits. There will likely be budget discussions which perhaps modify what it is, or perhaps reduce the threshold from what is currently proposed. But it is likely an issue that we're going to see some movement on, probably in 2024. So keep your eyes on that one. Non-competes. This issue sort of really caught me by surprise. The Biden administration, shortly after they were elected, announced a sort of a priority policy concern of reining in the use of non-competes across the nation. Historically, non-competes have been regulated on a state level, and some state courts are very friendly to non-competes. Some state courts are not. Pennsylvania, I like to say, Pennsylvania courts don't love non-competes, but they'll sort of hold their nose and enforce them if everything is done right. And oftentimes employers don't do everything right, and so the non-competes get thrown out. But certainly they are enforceable in Pennsylvania. Back in earlier this year, the FTC proposed a rule that would ban employers from imposing non-competes on their workers altogether. The public comment period for that proposed reg ended in April of this year, and essentially would not only sort of eliminate the use of non-competes, but could jeopardize the use of overly broad confidentiality agreements or non-solicitation provisions. The distinction between a non-compete and a non-solicitation, of course, is that a non-compete says you can't work for our competitors. A non-solicitation provision says you can go work wherever you want. You just can't solicit our customers or clients. Presently, the regulation is not in final form. It's not being enforced. This is another one of those regulations that's sort of in the proposed stage. The U.S. Chamber has either threatened or already filed a lawsuit challenging the enforcement or the finalization of this regulation. So I don't think it's anywhere. I don't think we've seen the last of it. I don't think the regulation is just going to take effect and all of a sudden all non-competes go away. But it's important to know that the FTC is not alone. This is a movement that has slowly emerged across the nation. We currently have about 30 states that have statutes that regulate non-competes in some way. They don't necessarily ban them, but they have specific requirements that apply. Pennsylvania does not have a statute. Essentially, what we have is courts determining whether a non-compete is reasonable and equitable or not. But what's notable here is the second bullet point. We have 6 states that have pretty much all out rejected non-competes. And if you look at that second bullet point, you'll see that several of them, they're not all blue states. I would expect California and Colorado to be on the list, maybe DC, maybe Minnesota, and they are on that list. But North Dakota and Oklahoma, that's surprising, and it sends the signal that this is not just a blue state issue. There are certain, I'd say, libertarian strains in some red states that think you should be able to work wherever you want to. So it is in some respects a bipartisan issue, and it wouldn't surprise me if we see at least some incremental movement on the national level, but not certain. The next bullet point it basically says that I wouldn't expect laws to be passed in Pennsylvania anytime soon on non-competes, but take a look, watch out for small bites from the governor's office. It wouldn't surprise me if we see something like the Commonwealth of Pennsylvania won't contract with customers or with vendors that use non-competes or something like that. I don't believe that's been proposed yet, but it wouldn't surprise me. That's the way that these issues tend to take hold on a legislative basis. Washington, D.C. enacted their ban just back in 2021. And also in 2021, we saw some movement from other states, again, not banning them altogether, but just sort of further restricting them. So it is a live issue that's emerging across the nation. Very quickly here, the Human Relations Act, which is Pennsylvania's non-discrimination law, it's sort of our equivalent of Title VII, was amended, and this doesn't happen every day. The Human Relations Act, is a fairly old law, and it doesn't get modified very often. But in light of court developments, including at the Supreme Court, the law was recently amended to specifically expand the definition of sex to include sexual orientation. Again, that's relatively old news, but potential impact for you if you have a EEO statement in your handbook. It may be wise to include sexual orientation or gender and gender identity in your EEO policy, as that will now reflect the law of the state. Likewise, the definition of race in the law was expanded to include hairstyles associated with race, which is, again, one of those issues that it hasn't really come across my desk, but I can certainly see the issue arising. So hairstyles that and other quote unquote traits historically associated with race are now protected, which would include hair texture, protective hairstyles such as braids, locks, and twists. The interesting question there, and I'm sure we'll get the question: does this protect white individuals who have dreadlocks, against discrimination if the whatever there's an aversion to dreadlocks? And I would submit that, yeah, I mean, regardless of the race, dreadlocks are probably now a protected trait under the Human Relations Act, regardless of race. Religious creed and all aspects of religious observance. Religion has long been a protected class under both federal and state law, but now there's an expanded definition that says it not only protects someone's belief, but also the manner in which they observe their religion. So, meaning, the day that they consider the Sabbath, the days that they consider holidays that they're unable to work. With that, I'm going to close up with a Supreme Court decision that came down in June that arose right here in good old Lancaster County. It's good entertainment to pull up the Wikipedia on this case, because you'll probably know the locations at which it arose, or at least some of you will. It all took place in the southern end of Lancaster County. Essentially, we had a mail carrier working for the U.S. Postal Service, and historically, as you know, the Postal Service doesn't deliver on Sundays. However, I probably, largely due to the growth of Amazon, Amazon subcontracted with the Postal Service to deliver some of their packages, and as a result of that, we started to see Sunday deliveries from our mailman. And we have an individual named Mr. Groff, who belonged to a particular denomination that forbid him from working on the Sunday Sabbath. He was assigned to the Quarryville post office, which became a very large hub for these Amazon deliveries. And as a result, he was oftentimes called upon to make Sunday deliveries, and he refused. Complicating this, the Postal Service has a union contract that only allowed for employees to be exempt from Sunday deliveries if certain conditions were met. So the Postal Service was trying to balance its duty to accommodate versus its collective bargaining agreement obligations. And the one step that they took, in addition to allowing him to swap shifts with coworkers, is that they moved him to the Holtwood post office, which a much lower volume, much fewer Sunday deliveries, and much easier to try to accommodate him when Sunday deliveries were necessary. However, you had a situation where coworkers would fall ill and couldn't deliver, so he was sort of the last man standing and was required to deliver, and he refused, and as a result, incurred attendance points and was eventually terminated. Historically, the employer's burden for withstanding a religious accommodation charge of this nature was to say, look, it's undue hardship in that it causes, some degree of cost to us. The Supreme Court said, no, you have to show more than it's costing you more money. It's a more basically paying more respect to religious observance. And now the new standard for determining whether an employer can establish an undue hardship and basically refuse to accommodate is, they say, it has to be assessed on a case-by-case basis. You have to show a significant impact on the conduct of the business, not just an inconvenience and not just additional minor expense. They also consider the size, the operating costs, and the nature of the business. And guess what? You don't get many larger employers than the U.S. Postal Service. So, really what they're saying there is, we're going to require the Postal Service to do a lot more in these situations than we would if you're a 5-employee shop. And then lastly, even if there is an undue hardship, you have to consider whether other accommodations would work, such as swapping shifts with employees, or covering the work at some other time, maybe doing a double shift on a Saturday rather than having to work on a Sunday. The takeaway here, obviously, is that religious accommodation requests now need to be taken much more seriously than ever before, and take a look at your policies and take a look at training, supervisory training regarding to this issue. With that, it's about 10:29. I'm going to turn it over to my partner, Micah, to bring it home. Thank you.
All right. Thanks, Eric. The topic of religious accommodations segues really nicely into the first topic and update that I want to provide you with, and that's updated activity by the EEOC. Historically, the EEOC's activity in releasing new guidance, releasing memoranda, has been sporadic at best. But in 2023, we saw two important pieces of guidance come from the EEOC. And the first that we want to talk about relates to the gradual but sure takeover of our lives by our computer overlords. I want to talk a little bit about artificial intelligence and the EEOC's memo that was released in May of 2023 relating to the use of artificial intelligence. So I don't think it's news to most people on the call that artificial intelligence and computer programs that use it are becoming more and more prevalent by the day. Programs like ChatGPT are being used by a wide range of individuals to draft policies, to, in one instance that was somewhat famous, draft a brief, and the brief happened to be full of non-existent case law, which got an attorney in trouble. So that kind of highlights, artificial intelligence isn't necessarily as reliable as it might seem on its face. And the EEOC issued a memo in May just advising employers that the commission is mindful of the fact that the use of artificial intelligence programs in the employment context creates some discrimination risk. So first, how is that possible? Well, there are programs being developed to screen job candidates, analyze resumes and applications, and even potentially predict a candidate's success in a particular job and their cultural fit with an employer's workplace. And so you can imagine a situation in which an employer would want to take advantage of this new shiny technology, have applicants submit online applications, run those applications through an artificial intelligence algorithm, have the algorithm analyze those candidates who are likely to be the most successful, spit out a list of candidates who might be successful onto HR so that HR can set up interviews and ultimately make a selection. So what's the problem with that? Well, the problem with that could be adverse impact, right? And just as a refresher, adverse impact is a facially neutral policy that results in a discriminatory outcome. And what the particular concern is that the EEOC addressed in its memo earlier this year was algorithmic adverse impacts, right? So the code that's written into these computer systems upon which they are making these decisions and recommendations on hiring and predicting candidate success may exclude a certain class of individuals based on protected traits. And while the algorithm is applied equally to every applicant, the impact of the algorithm's output may result in an adverse impact. And the EEOC has made it clear that from an enforcement standpoint, ultimately the employer is going to be responsible for that adverse impact should it occur. So it's not going to be a get out of jail free card to say, hey, we ran it through the computer system, and when we bought this computer system, we were assured that it was going to function in a way that complies with the law. And so big takeaway here is if you're considering using artificial intelligence to facilitate hiring process or in any aspect of your employee relations, you should have an understanding, a very clear understanding of how it works. You should monitor the results that this system is producing to detect any potential adverse impact type trends that are coming from it. You should be able to explain how you use the system. And if you're going to use it, again, consider defining a policy, using a policy to define how and when AI will be used in your organization. So it's not something that we want to allow, employees to use at their own discretion in employee relations issues. There should be a uniform policy. Everyone should understand what that policy is if we are going to permit AI to be used in the employment context. The next area that the EEOC has provided some updated guidance is the topic of harassment in the workplace. So for the first time since 1999, the EEOC has issued a notice of proposed rulemaking to change its formal official regulatory guidance regarding workplace harassment. And so the memo that we just talked about earlier on artificial intelligence, it's not an official regulatory action. It's more of a notice to employers. This update with respect to workplace harassment is an official regulatory action that's been taken by the EEOC. The notice of proposed rulemaking was issued earlier this year. The proposed rule, which we'll talk about sort of the details of that here in a minute, was published. Public comment closed on November 1st. And now public comment is closed, and we're waiting on the EEOC to formally publish its final rule. So why the update? Well, as I said earlier, the EEOC last updated this guidance in 1999. So let's just take a quick minute to think about how the world has changed and workplaces have changed since 1999. The two most prevalent topics that are addressed in this new and updated guidance relate to sexual orientation and gender identity issues in the workplace. So the proposed new guidance clarifies that sex-based discrimination includes discrimination on sexual orientation and gender identity. So that's something I think that most of us are aware of. We've seen case law come out in favor of including sexual orientation and gender identity under the definition of sex. But the new guidance is providing examples of what this sex-based discrimination might look like as it relates to sexual orientation and gender identity. So straight from the rule, epithets regarding sexual orientation or gender identity, physical assault, harassment because an individual does not present in a manner that would stereotypically be associated with that person's gender. So if a person has an assigned gender of male and they dress in traditionally female clothing, harassing them for presenting in that manner under the EEOC's guidance will be considered sex-based discrimination and harassment. Likewise, intentional and repeated use of a name or pronoun inconsistent with an individual's gender identity. The simple term for that is misgendering. So if we have an employee who is repeatedly calling a transgender female sir or Mr. Intentionally and repeated, that can create liability for a hostile working environment on the basis of sex under the new under the enforcement guidance. And then likewise, denial of access to bathroom facilities or other sex segregated facilities in the workplace that are inconsistent with an individual's gender identity. So we can see, the EEOC is kind of filling in some of the gaps of what does this new case law mean? What do these developments look like as far as including sexual orientation, gender identity as sex-based discrimination? Takeaway on this is it's certainly worth reviewing this new guidance. It's certainly worth making sure that managerial and supervisory level employees have an understanding of what this guidance includes. Actions that may have been either questionable discrimination before or potentially even not considered discrimination before are now clarified by this new guidance. So certainly worth making sure that everyone's on the same page in the workplace as to what the EEOC is considering to be sex-based discrimination. We've also seen some congressional activity over the course of the end of 2022 and bleeding over into this year. And the first is the Providing Urgent Maternal Protections for Nursing Mothers Act. And the first thing I thought when I saw this law was, hey, Congress is finally getting really good at naming laws. This is the PUMP Act, and it relates to protections provided for nursing mothers in the workplace. It is an amendment to the Fair Labor Standards Act. And there were some amendments issued originally in 2010, which did require employers to provide lactation time and space to non-exempt employees. The PUMP Act takes those expansions a step further and says this applies to everybody, both exempt and non-exempt in the workplace. The PUMP Act explicitly requires that an employee receives reasonable break time for each time that she needs to express breast milk for up to 1 year following the birth of her child. Employers must provide a reasonable private place that's free from intrusion. So it has to be somewhere out of public view, has to be somewhere where the employee is not going to be walked in on while she's expressing breast milk. It cannot be a bathroom. That is clarified explicitly in the statute. And the break may be unpaid unless the employee is performing work. And so that unless the employee is performing work is one of those little traps that we have to be aware of as employers, right? So just imagine a situation, you have a nursing mother, she's a non-exempt employee, clocks out to take a break to express breast milk, and she takes her phone into the break area with her. And while she's pumping, she's answering emails, she may be taking phone calls, she may be writing reports or doing other productive type work. And in those scenarios, we have to make sure that we're compensating for that time. So the best way to do that is either expressly prohibit an employee from working during a pumping break and make sure that, they're not in an area where they're able to continue, sitting at their computer and working and typing away or doing any productive work, or allowing those breaks to be paid and allowing employees to continue working. So that's something that employers can set as policy considerations, but it's something to keep your eye on as you move forward with complying with the PUMP Act. Another couple of really important updates with respect to the PUMP Act. It does make it possible for an employee to file a lawsuit against an employer that violates this law. So before the PUMP Act came into effect at the end of last year, employees who were harmed when their employer didn't provide the break were not necessarily able to seek a monetary remedy in court. Now they are. And this new act also, again, sort of clarifies that issue about counting time actually worked during the pumping time as compensable if an employee is actually doing work. So my optimism for Congress's naming statutes quickly changed with our next law that came into effect, which is the Pregnant Workers Fairness Act. No cool acronym here, but a very important law that took effect earlier this year in June. And I can tell you, as someone who counsels employers day in and day out, this is going to be a law that we have to be very careful to comply with. So the Pregnant Workers Fairness Act expanded existing federal law with respect to accommodation of pregnant employees. So before this act took effect, the only thing that employers had to concern themselves with accommodating as it relates to pregnant employees was medical restrictions that rendered the employee disabled during their pregnancy. So run-of-the-mill pregnancy symptoms like fatigue, morning sickness, those types of things, we didn't necessarily have to worry about accommodating. We'll talk about in a minute. Under the ADA, those were considered transitory minor conditions, and an accommodation wasn't necessarily required. Now, under the Pregnant Workers Fairness Act, employers must accommodate known limitations related to pregnancy, childbirth, and associated medical conditions with either pregnancy or childbirth, regardless of whether they rise to a disability under the definition provided in the Americans with Disabilities Act. So employers are going to have to provide accommodations for morning sickness, fatigue, things like that, unless those accommodations would impose an undue hardship on the employer. The Act also clarifies that employers cannot default to requiring an employee to use leave just as, hey, this is the accommodation we're offering you. We've got to go through an interactive process, and we have to determine whether the employee is going to be able to perform the essential functions of their job. And if so, we can't force them out on leave. We have to provide whatever accommodation is going to allow them to continue actively working. And the Act also adds an additional layer of protection with respect to pregnant employees, and that is accommodations also have to be provided even if an employee can't perform all of the essential job functions, as long as their inability to perform the function is temporary. So again, let's think about the idea of morning sickness, right? Previously, an employer would likely not be able to require, likely not be required to accommodate an employee who felt ill in the morning and may be late to work. Once she gets to work, she's able to do all of her normal job functions. Now, the Pregnant Workers Fairness Act makes it pretty clear that an accommodation of allowing her to push back her start time is very likely required in this situation, unless we could prove an undue hardship. So who's covered by this? Employers in the public and private sector with at least 15 employees. And again, we talk about the notion of engaging in the interactive process with these employees who qualify under this act. We can't discharge them. We can't terminate them for requesting accommodations or for having these pregnancy-related limitations. We also saw this year, on our next slide, some proposed regulations that were issued to fill in some of the gaps under the Pregnant Workers Fairness Act. These regulations were issued in August of this year. Comment period closed in October. And again, we're waiting on final rules to be published. These regulations kind of, again, clarify and fill in some of the gaps and questions that we might have had about how this act applies exactly. So we talked about the idea of an employee being qualified for a position even if they can't presently perform essential functions of their job, but will be able to in the near future. Regulations define near future as approximately 40 weeks. I wish I could convince my wife that 40 weeks was the near future when she asked me to do things like paint the bedroom. And I tell her, hey, it's going to be in the near future, 40 weeks. Most of us wouldn't think of 10 months from now as being the near future, but the regulations clarify that for the purposes of this law, that certainly is the case. And we think about, the timing of that, right? Why 10 months? Well, it covers the pregnancy and it covers a month post-pregnancy to address any issues that might arise either throughout the pregnancy or immediately afterwards during childbirth. Undue hardship factors are also clarified in the regulations that were published. So undue hardship is an action that fundamentally alters the nature or operation of an employer's business, or is unduly costly, expensive. It creates a substantial disruption. So those are the three things that we're looking for: is cost, expense, and substantial disruption to the business. Factors to consider that relate to the undue hardship analysis are the nature of the net cost of the accommodation and the overall financial resources of the employer. So what might be an undue hardship for a mom and pop business with 15 employees and they're just under the coverage of the law may not be a hardship for Coca-Cola, right? So overall financial resources are an important consideration. And then we just want to move to the next slide and talk about the interrelationship between the ADA and the Pregnant Workers Fairness Protection Act. So there is some overlap, as you can see, right? There's an interactive process. There are reasonable accommodation principles. Undue hardship is applicable in both scenarios. But again, the ADA requires an impairment that substantially limits a major life activity, whereas the Pregnant Workers Fairness Act covers temporary conditions. And we also cannot require employees to take paid or unpaid leave as an accommodation if any other possible accommodation exists. Given that we're in the time of year where folks like to have some time off, I think many of us have probably been in the situation where employees have run through PTO and they're looking for some other form of leave to miss some time from work during the holidays. Always a good time to refresh our understanding of key sources of legal obligations to provide leave and or accommodations. So Americans with Disabilities Act, 15 or more employees. Pennsylvania Human Relations Act contains similar accommodation requirements. Employers have to provide reasonable accommodations for an applicant or employee's known disability that allows them to perform the essential functions of their job, again, unless we have an undue hardship. Disability for this context is a physical or mental impairment that substantially limits a major life activity. And the process for deciding on this is interactive dialogue to determine whether the employee requires an accommodation first and whether the accommodation could be provided without undue hardship. Again, this time of year, it's important to remember under the ADA PHRA, an employee is not entitled to their preferred accommodation. They're entitled to an accommodation that will effectively allow them to perform the essential functions of their job. So why is that important at this time of year? Well, we have an employee that comes in and says, hey, you know what? I need to work from home. I have ADHD. I can't be, I'm easily distracted by noise at my cubicle. And so I want to work from home for the month of December because my ADHD is flaring up really, really badly this month. Well, if we have a vacant office on a quiet side of the building, there's no noise. If that accommodation will allow the employee to perform the essential functions of their job, we can tell the employee, we're not going to give you the remote work or any leave. We're going to make a space available for you that's quiet here in the workplace. Another common source of leave this time of year is the FMLA. So obligation here is for covered employers, which is 50 plus employees. We must provide employees who are eligible for FMLA up to 12 weeks of job protected leave. For the purpose of this conversation, we're looking for a serious health condition on the part of the employee. And the process here is much more forms driven, right? We issue a certification. Certification's completed by the employee's healthcare provider. Either they meet the definition of serious health condition or not. If they do, typically we're going to have to grant them the ability to use FMLA leave, and we cannot retaliate or discriminate against that employee for requesting FMLA leave. As Eric alluded to earlier, we also saw some updates from the National Labor Relations Board. First deals with severance agreements and came to us through a case known as Micah. This decision was issued to address confidentiality and non-disparagement provisions in a severance agreement. So we've all seen severance agreements that say, you can't disclose the existence of this agreement to any third party except for your spouse or your legal advisor or your accountant. And we've also seen provisions in these agreements that say you can't say anything bad about the company if you accept the severance. These issues were brought before the National Labor Relations Board under a concern that those provisions violate employees' Section 7 rights under the National Labor Relations Act. So the National Labor Relations Act, again, applies to most private sector employers and protects employees' rights to engage in protected concerted activity whether they're in a union or not. With respect to the confidentiality provision, the National Labor Relations Board found that language that says an employee can't discuss the existence of the agreement precludes those employees from disclosing the existence of potentially unlawful provisions in the agreement to other employees who may have been offered the severance. And the board also found that the language tends to coerce employees from filing unfair labor practice charges or voluntarily assisting the board in investigations. So the board said, broad, expansive confidentiality provisions contravene public policy. Likewise, non-disclosure, non-disparagement, where an employee is prohibited from making comments that would reflect negatively on the employer. National Labor Relations Board says, those prohibitions prevent statements to the employer's employees or general public that could implicate unfair labor practices, right? If the employer is engaging in unlawful activity and the employee says, hey, my employer did something wrong, and it's true, the non-disparagement provision, if it's broadly applied, would prevent them from making those statements. And so the board said, no more on that. We can't have those broad prohibitions in severance agreements. So shortly after this decision comes out, the general counsel comes out and says, we're not looking at just severance agreements. This is going to apply from our perspective to settlement agreements, non-competes, non-solicitations. So takeaway here is make sure that if you're having severance agreements, separation agreements, they're reviewed by legal counsel to ensure that they're not overly broad under the Micah-McLaren decision. National Labor Relations Board also took a look at work rules in the case of Stericycle. And prior to the Stericycle case earlier this year, there was a rule called the Boeing rule, which required the evaluation and balancing of two factors when determining whether work-related policies violate the National Labor Relations Act. Those two policies were the two factors were the extent of the potential impact on National Labor Relations Act rights and the legitimate justifications associated with the rules. And there was sort of a balancing there. Each side got to explain, their position, and the board would weigh these factors. Under the new rule, the burden has shifted very favorably to employees seeking to prove the unlawfulness of a work rule. And that burden now is that the general counsel of the National Labor Relations Board bears the burden of showing that a rule is presumptively unlawful because it could be interpreted to limit employee rights. This is important because alternative interpretations don't save the rule anymore. That balancing act doesn't happen anymore. If it could be interpreted to limit employee rights, then it's presumptively unlawful. Then the burden shifts to the employer to show that the rule advances a legitimate and substantial business interest, and the employer is unable to advance that interest with a more narrowly tailored policy. So good time, end of the year, review your policies, consider whether they have objective business purposes, and if not, consider taking them out of your handbook. If they do, let's make sure they're narrowly tailored for the proper effect. Last thing we want to talk about today is employer liability under serving alcohol at holiday parties. So this one comes to us from the Raucous and Rowdy crowd at the Dairy Farmers of America. Dairy Farmers of America was hosting a golf outing. Employees contributed money to purchase alcohol. They were allowed to self-serve alcohol. One particular employee who was over age 21 was an alcoholic, and he served himself beyond the point of being visibly intoxicated. He hops in his car to leave the golf outing, hits a motorcyclist, fortunately doesn't kill the motorcyclist, but caused grievous injuries. Motorcyclist sues the dairy farmers and says, hey, you served him this alcohol. You knew he was drunk when you left, and now you owe me money. Pennsylvania Supreme Court analyzed this case under the Pennsylvania Dram Shop Act and determined that social hosts, including employers who are not licensed to sell alcohol, are not held liable for negligence of intoxicated guests or liable under the Dram Shop Act. So this isn't a blank check to indiscriminately serve at your holiday parties. If this employee had been under 21, very likely there would have been a different result. So as we're looking to spread holiday cheer this time of year, always a good idea, if alcohol is served at a company event, have a vendor or a licensed party serve that alcohol to make sure that minors aren't accessing and folks aren't getting overserved.